Good morning. May it please the Court, and Catherine Semmel appearing on behalf of the Commonwealth. The motion judge, Judge Feely, erred in this case as a matter of law and fact when he dismissed the second-degree murder indictment on the basis of what he found to be consistent, indefinite evidence supporting a heat of passion defense where the defendant repeatedly stabbed and killed this unarmed victim. I would suggest it is a matter of settled law and practice in Massachusetts that the Commonwealth is not required to disprove defenses or mitigating circumstances before the grand jury, and that the Commonwealth need not instruct on lesser included defenses or offenses in the case. And I would suggest that this is consistent with the general rule that prosecutors are not required, in fact, to instruct on the elements of offenses in general. Instead, it is sufficient if the Commonwealth provides the statutory language in support of the offense. And I think this stems from an understanding of the limited role of grand juries, their accusatory role rather than adjudicative, in determining whether or not there is even cause to go to trial in a case. I think the wisdom of this approach is evident when you weigh the competing interests that are involved. I think there's some concern that instruction on lesser included offenses and a whole myriad of circumstances that could arise would divert the grand jury from their major purpose, which is determine whether there is any basis on which the Commonwealth's charge can be sustained. And it would not be limited to manslaughter, heat of passion. It could be applied in a myriad of circumstances, criminal responsibility, entrapment, any case in which when it goes to trial, the jury might return a lesser verdict for some reason would become fodder for the grand jury.
Let me ask you this. Would there be an Odell problem if in the grand jury the jury had not been told that the death occurred after the defendant had been robbed?
I think that the prosecutor is required to fairly present the facts to the grand jury, and but that has been distinguished from any circumstance where the Commonwealth must instruct the grand jury on specific lesser included offenses or defenses.
But so you're saying the jury must understand that this death occurred in the context of a robbery, otherwise that would be unfair, but the grand jury does not need to know the practical consequence of that, that is that this may actually be a manslaughter as opposed to a murder.
I think that this seeming imbalance that the court is mentioning, I think it is. I think that the point is that the existence of defenses, the existence of mitigating circumstances will almost always be a question of fact for the jury at trial. I don't think there are circumstances. It would certainly be very rare for there to be circumstances where the evidence of a defense was so clear and uncontrovertible that it should, in fact, preclude a case from going to trial. And
well, the issue is not whether the case goes to trial. The issue is whether it goes to trial as a murder with a mandatory life with parole sentence hanging over the defendant's head as an adult, or whether it goes to trial as a youthful offender, voluntary manslaughter. You're saying that the jury essentially is irrelevant with regard to that? All it does is says that this person is responsible for a death and therefore they will have to accept what the prosecutor's proposal is? That seems to be pragmatically what you're asking.
I think the system gives the grand jurors a certain amount of discretion to pursue matters, and I think that the.
But what does that mean if they don't? I mean, if you don't tell them they have a choice, we sort of. I mean, I gather the law is that if somebody said, "What about voluntary manslaughter?" then the prosecutor would have to tell them, right?
Yes, absolutely.
But what if this is not a sophisticated grand jury which knows of that? Then they can be they can be deprived of the opportunity to even consider whether this is more properly indicted as a voluntary manslaughter as opposed to a second-degree murder?
Well, I don't think it's the purpose of the grand jury to second-guess the Commonwealth as long as the prosecution has supported an offense. But the major point, I think, is that there are, and the reason why I think we're not required to instruct is the existence of other protections. And while we can say that grand jurors may not be sophisticated, I was struck when I was rereading the transcripts in this case by the questions that the grand jurors did ask in this case. And while the specific elements of provocation and self-defense are complicated and hard to explain and hard to apply, the basic concepts are not. And in this case, grand jurors asked Darren Colucci, what did you say when you pointed your finger at the defendant? And you mean you had no weapons at all, no bats, no nothing? And did you say you had a weapon, even though you didn't? Those are questions posed by the grand jurors, and they asked his friends, were they known to carry weapons? Was anyone carrying a backpack that day? What method did they say they were going to rob them? I don't think that it is irrational to say that if, in fact, the evidence of a defense or mitigating circumstances is so clear and incontrovertible that it should preclude a trial from going forward, that grand jurors would be cognizant of that, of the basic justice involved in it.
But you haven't given them the choice, because clearly somebody has died and with a knife, and those circumstances that you're talking about wouldn't mean necessarily to somebody that they didn't think a crime had occurred. It just may not, it may be a different crime. So you really aren't giving them the full picture, or that would be the argument.
That would be the argument, and yet that is the practice. That is the practice that this court has endorsed, and I think that there are practical reasons in support of it, because of the fact that it will most always be a jury question, because of the fact that there are other checks on the prosecutor that come into play.
Like what? I mean, in this instance, like what?
In this instance, I mean, there's certainly the prosecution routinely exercises its discretion in the charging of offenses. The Commonwealth exercised its discretion here when it didn't seek a first-degree murder charge, but in fact sought a second degree. There are circumstances where the Commonwealth, when they believe that it is a close call, when they are themselves undecided, that we will on our own instruct grand jurors and seek input from them on different levels of charges. But that's different from injecting it wholesale into the grand jury proceedings, particularly when the grand jury, if they're troubled by the offense, by the evidence, can seek instruction from the prosecutor, can even go back and seek instruction from the court if they're not satisfied. And I think that the protections, that the competing interests involved do not suggest that this process is wrong. And
Can I ask you, in the judge's decision, I was a little confused. Was he suggesting that had this gone to trial, he would have directed a verdict of not guilty based on the evidence?
I think he was trying hard not to frame it in those terms, because that would obviously be wrong. But yes, I think that's essentially what he did.
You mean of second-degree murder?
Yeah. Right.
Yeah.
Right.
Yes, I think that's essentially what he did in this case. Absolutely. I would just note that the injecting self-defense, mitigating circumstances into the grand jury proceedings has potential problems as well. The evidence before the grand jury is not complete. It's often based on hearsay. The Commonwealth doesn't have an opportunity to argue and marshal the evidence on our behalf, and it can be on the basis of defenses which a defendant may not even rely on at trial. And to say that we're going to possibly preclude the prosecution from bringing a case to trial on the basis of such evidence is different from just relying on this evidence to say, oh, the prosecution got over the bar, the prosecution has provided some cause to believe that a crime has occurred. And I think that an injustice could result in that case.
Why is the prosecution precluded from presenting all the evidence that would defeat a claim of reasonable provocation? The defense doesn't have that opportunity, but the prosecution does.
The prosecution has that opportunity. The question is, does the prosecution have the means yet to produce all that evidence? This is a preliminary stage in the proceeding. I think at the first grand jury, we didn't even have an autopsy report. There's evidence that develops. Forensic evidence does not come back at the drop of a hat. And even though we have the opportunity to, it's not a real opportunity in the sense of at trial.
But you did have the information at this point.
We
And
have
that
forensic evidence that we're
wouldn't be a
still
rule
waiting
that
for
says
in this
look for it,
case.
but you haven't, and that's why you had to go twice, because you had the information. That was the problem with the first go-around.
The problem was, yeah, a
Right.
statement
and now
that wasn't
you have
produced.
it, and then, but the information taken together, if they knew, it wasn't just a defense, but it was an obligation to disprove. You don't think that?
I'm sorry, Your Honor.
I'm just saying that it's not the hurdle you're proposing. It looks like a lesser hurdle. Whatever you have that's exculpatory that you present, explain it.
And the problem is that injects a whole different level into the grand jury proceedings, and requirements that this court has never sustained on any general level. And I think it is as apt to produce inequities as it is to produce any significant protection from the defendants. When once again, I have to say, as a matter of practical reality, most defenses, most mitigating circumstances come down to a question of fact for the jury, and that is very evident under the facts of this particular case.
If I understand this correctly, the prosecutor is requesting that the grand jury return an indictment for second-degree murder.
That's correct.
And that's the only crime. It would be that crime or no crime.
That's correct. And the jury at that point can return a no bill. They can ask for clarification. They can seek further evidence.
And if they return a no bill, you can come back again. There's no double jeopardy bar to going back with a little more evidence or filling a gap, right?
That's true, Your Honor.
But of course, at trial, you couldn't do that. You couldn't give the jury no option of voluntary manslaughter. So you're affirmatively denying the grand jury an option which you would have to give to the petty jury.
That's true, and I think it's warranted by the different functions they provide. I think that
I'm
the possibility
I'm trying to understand the function. I mean, by this indictment, they've given you the hammer of a mandatory life sentence. I mean, that's an enormous power you now have, enormous risk which the defendant now faces if they go to trial. Why do you essentially get that without the grand jury even knowing that it has an option?
I think that it's based on the fact that probable cause to believe a second-degree murder does not depend upon whether or not defenses can be raised at trial. That the affirmative proof or the affirmative evidence in support of a charge of second-degree murder is simply not negated by the fact that defenses can be raised down the road. And I think that the point has been expressed maybe best by the U.S. Supreme Court, implicitly adopted by this court by its rulings, which is, that the point of the grand jury is to determine whether the Commonwealth's evidence, if unexplained, uncontradicted, unsupplemented, could support the charge in this case. And I think that is truly the function of the grand jury.
So if let's say this were a gun case and you picked somebody up because they had an unlicensed gun and turns out they have a license, it's okay because it's a crime to present it without the information that would actually make it not a crime, the defense?
Well, I think that a specific exception has been carved out. And with regard to the Landry case that the defense cites, FID, that in the case where there's that objective manifestation of legitimating the defendant's conduct, for instance, that it's not enough to arrest. But I would just say, if, for instance, the police...
Not that?
I don't think that it's that. And I think it's just because of the nature of the analysis, that any defense requires a qualitative analysis of all the facts, of all the circumstances by a jury. And as case in point, I would say that if police came upon an individual in a road and he had a gun and produced an FID card, the case law says that they wouldn't have probable cause to arrest him. But if that same defendant had a gun and just shot somebody and asserted without contradiction from anybody that it was in self-defense, I don't think anybody would say that the police couldn't arrest him for the murder in that case. It's a discrete exception, I think. As for the facts in this case, I would just rely on my brief and just reiterate that I don't think that any judge, if faced with the facts presented here, at the end of trial would have directed a verdict not guilty as a second-degree murder under the standard of proof beyond a reasonable doubt, and it certainly did not negate probable cause in this case.
All right, thank you very much.
Thank you.
May it please the court, my name is Jonathan Shapiro, and I represent the defendant in this case, Javon Walczak. The issue is not, as the Commonwealth argues, whether the Commonwealth is required to disprove evidence of disprove defenses, such as self-defense or mitigating circumstances before the grand jury. The main issue in this case is whether the evidence that was presented to the grand jury is sufficient to establish probable cause that Javon Walczak committed the crime of second-degree murder.
Which is an unlawful killing with malice.
Correct.
And
And
if you
there's
have,
not enough evidence to conclude he killed someone
The
with
trial
malice?
judge, after a very careful review of all the evidence, concluded that the evidence of reasonable provocation or sudden combat was consistent, definite, and essentially uncontradicted.
So that a directed verdict would be required on the basis of that evidence? Is that what you're suggesting? Had this been a trial, which it was not?
Judge Feely heard motions to dismiss 2 times. The first time, he dismissed the indictment on Odell Mayfield
Right,
ground.
and it was re-indicted.
And in the course of that decision, where he said and concluded that he thought that the evidence barely met the standard of probable cause, he said that as far as he was concerned, at the trial stage, if this were the evidence presented, a trial judge would be warranted in not sending it to the jury on the crime of second-degree murder.
Well, if we look at this evidence and conclude that a trial judge could have sent it to the jury and wouldn't be required as a matter of law to direct a verdict, then why should we say,
No.
but a grand jury is a whole different thing?
On the second round, where the judge considered the evidence and concluded that it didn't meet the McCarthy standard, clearly he was saying that as a matter of law, this
Was
would
a
not
not
go to
guilty.
the jury.
As
Correct.
a matter of law, this was a not guilty
And that's
on second-degree
because
murder.
there was essentially undisputed evidence of reasonable provocation or sudden combat, which is essentially, where there is some evidence of that, an element of the crime. So the Commonwealth's argument that it doesn't have to deal with reasonable provocation or sudden combat or even self-defense because it's not an element of the crime is simply wrong.
So what could the Commonwealth have done to present one fact, if believed by the jury, would rebut the provocation?
Well,
Multiple stab wounds, chasing the victim, stabbing him multiple times, might that?
if there was, let's say, clear evidence that...
Clear? It doesn't have to be
well,
clear. What-
If there were any evidence that the assailants, the original assailants, the victim and Darren Colucci, if they had withdrawn from the fight, giving the opportunity for the fight to be over, that would certainly be evidence which undermined reasonable provocation or sudden combat.
And are you suggesting that the district attorney would then have to explain to the grand jury, now you can consider, but on the other hand, and oh, by the way, the law is, or just any evidence that someone could discern if it were believed or viewed in a way that might be argued by good advocates in front of a jury?
That's a very separate issue as to whether or not the grand jury has to be instructed with respect to the elements.
Oh, so you're saying they don't have to be instructed, but
Well-
after the fact, someone has to look at with this in a microscope and say, is there anything here that maybe at trial could have been used to argue to rebut provocation?
No, that's certainly not our argument. Our argument is, look at this evidence, and as the trial judge found, if there is no evidence from which a reasonable person who is familiar with the law could conclude that this is second-degree murder, given the virtually undisputed and uncontradicted evidence of reasonable provocation or sudden combat, then the Commonwealth has not met its burden of probable cause. That's the standard.
On the facts of this case, though, you've got a knife, so one could infer that somebody has the requisite intent for murder from the use of the knife. Don't have to, but you could, right?
Correct.
And so the rest of the, so the evidence that suggests reasonable provocation, et cetera, could be believed or not. I mean, I just don't know why that wipes out that sort of inference in terms of allowing this to go forward.
Well, as the trial judge considered it, he concluded that one of the essential elements of the crime of second-degree murder, to wit, the absence of mitigating circumstances,
Clearly, the
was
Commonwealth would have
not
to prove
presented,
that.
and there was no evidence of that presented to the grand jury. Now, the thrust or the logical conclusion of the Commonwealth's argument that it doesn't have to be concerned, and the grand jury can ignore evidence of provocation or sudden combat, would lead to, I suggest, the unacceptable consequences that whenever there's a homicide where a deadly weapon is used, that it becomes a murder case regardless of undisputed evidence that there was reasonable provocation, there was self-defense, or that there was sudden combat. And that's certainly not the law, and that would certainly undermine the historic function of the grand jury as providing some check on the prosecution. As it now stands, according to the Commonwealth's argument, if they go and present evidence of a homicide, and it turns out that a deadly weapon was used, therefore you can infer malice, and it doesn't matter if there's uncontradicted evidence that undermines the conclusion of malice.
So what you're saying is the district attorney has no obligation to explain this to the grand jury. No obligation. You told me no obligation to instruct on the various degrees of murder and how they might use the evidence. But just so long as there's a piece that later on someone could argue was evidence rebutting provocation or whatever the mitigating factor might be, that's enough.
Not rebutting, actually presenting, don't you mean? Presenting
Rebutting provocation. Rebutting provocation. You're saying that the Commonwealth has to prove a lack of provocation beyond a reasonable doubt, right?
Well,
that's what you're saying.
That's certainly their burden.
And here there's
at
no
trial.
evidence from which the jury could conclude.
Here, there's undisputed evidence of provocation, period.
But so in every case where there's undisputed evidence of provocation, but also evidence that somebody could infer was malice, and I'm not just talking about just by the fact, I'm not talking about this case, just hypothetically. You've got a case where when it goes to trial, there's clearly going to be an instruction on provocation. But there's also, a reasonable juror could find second-degree murder. In all of those cases, under your rule, because that evidence is there, the prosecutor has to offer the grand jury manslaughter as a possible indicted crime. Is that right?
Again, as far as instructing the grand jury, which is a separate issue, we think that is required under circumstances like this, because otherwise we think it's impossible for the grand jury to do its job. This court has taken great pains in the Odell-Mayfield line of cases to require the prosecutor to present the grand jury with all the facts, including exculpatory evidence, so that it can do its job.
Not all the facts. Not all the facts. They're not required to present every bit of evidence they have to rebut
That's
every
correct.
conceivable defense
They
at
have
all.
to, they have to present enough of the
They
facts.
can't distort the presentation.
Or mislead, and they have to provide exculpatory evidence, and the
Some,
reason, and the
depends.
reason for that is so that the grand jury can do its job.
So it's not distorted. So the
Correct.
process is not distorted. What was distorting about this process?
We think it's equally distorted if the grand jury is not told the relevance or significance
Okay,
of
now-
the evidence that is presented.
So now you're telling me they do have to be instructed that they have these options.
That, I never said anything but that. I said there are two issues. One is the probable cause issue, where the trial judge found the absence of probable cause. We argue not only was there a lack of probable cause, but in addition, there is a responsibility, at least in a case like this, where there is such a, in the words of the trial judge, consistent and definite evidence of reasonable provocation or sudden combat and self-defense, that the grand jury is at least told that this may make a difference.
What if there
And
were
that-
some evidence of insanity? Would the prosecutor have to introduce evidence of sanity?
Or say you could find a no bill because this person is not, it's a possibility, instruct that you could find the person could be not guilty by reason of lack of criminal responsibility, therefore that translates in this context to a no bill?
I think, and of course this is very fact-dependent, but if a defendant in a particular case was certifiably insane, the grand jury would have to be told that, and that the failure to explain that to the grand jury, and presumably also the failure to explain to the grand jury that this might affect
No.
its judgment.
There's some evidence that a defendant was being treated for mental illness and had been treated for mental illness for 15 years. And he was acting bizarrely at the time of the killing. There's some evidence of insanity. Does the Commonwealth have to produce a psychiatrist at the grand jury?
I would say no, but I think that they would have to produce that evidence. I don't think they could exclude that from the presentation, because clearly...
So does the case get no billed because there was the evidence of insanity was not refuted?
No,
Well, so why doesn't the same result obtain here?
because in a case like that, presumably, there would be probable cause, sufficient evidence of probable cause with respect to the crime charged.
The Commonwealth has to prove or disprove insanity beyond a reasonable doubt if it's raised.
At trial, it does.
Just the way they have to disprove sudden
Provocation.
transport of passion. Provocation.
That's true. The question ultimately, we think, comes down to here whether or not, on all of the evidence presented, a reasonable juror, a reasonable person familiar with the law could conclude that Javon Walczak committed second-degree murder. The trial judge concluded that it could not, and dismissed the indictment.
Now, the issue of probable cause gets a little more complicated with respect to the reasonable provocation issue, because it's easy with regard to second-degree murder to say there's probable cause to believe that he committed the act and that he intended to thrust the knife. But how do you deal with probable cause when the Commonwealth's burden is to prove beyond a reasonable doubt the absence of reasonable provocation? How does probable cause fit into that calculation? I mean, how do we define what you want?
I think basically you have to, there has to be some evidence before the grand jury on the basis of which the grand jury could conclude that there wasn't reasonable provocation.
Well, there was a
It doesn't have to be undisputed. The cases which the Commonwealth relies upon, all involve conflicting evidence. There was evidence on both sides, evidence of reasonable provocation and evidence of no reasonable provocation, evidence of self-defense and no self-defense. And in those cases, clearly it's not for the grand jury to resolve the factual matter, that's for the trial. But where there is no conflicting evidence, as in this case, where the undisputed evidence is that two young men attacked the defendant in the middle of the night
In
on
a
a
drug
lonely
deal.
street corner
In a drug deal that had gone bad.
and tried to rob him, and he pulled a knife after being attacked by two people, one in front of him, one behind him, and he pulled the knife after the fight started, after he had attempted to resist using his fists, only after he was jumped from behind did he
You're
pull
really
the
getting
knife.
deeply into your view of the facts.
Well-
These facts could be argued a different way. He was, what, stabbed 6 times in the neck, 11 times overall?
All that is completely consistent with the melee,
It may be.
which the evidence supports. And frankly, if you look at the Commonwealth's attempt to justify or explain these facts in a way that would undermine reasonable provocation, it becomes absurd. Their argument that the defendant was the aggressor because at some point during the fight, one of the other people attempted to protect himself. These are
really questions for a jury.
well.
Well, I'm afraid your time is up. Thank you, sir.
Thank you.
Second case here.